We're going to go ahead and get the program started now, and I'm delighted to welcome everyone to our Influential Voices series. This is the virtual edition, which Seattle University School of Law hosts to spotlight outstanding lawyers and legal minds from across the country. My role in these programs is often to introduce scholars, public intellectuals, and advocates from other law schools. But it's a particular pleasure for me to be called upon this evening to introduce our very own 2006 alumnus, Brian J. Sutherland. Mr. Sutherland is an experienced trial and appellate civil rights lawyer. He received his BA in English Literature cum laude from the University of Washington and his JD summa cum laude from Seattle University School of Law in 2006. While our student, Brian, was on the Seattle University Law Review and published his note or comment in that journal entitled Killing Jim Crow and the Undead Non-Delegation Doctrine. Following graduation, he was a staff attorney for the ACLU Voting Rights Project in Atlanta, Georgia, where he focused on state and federal constitutional voting rights litigation. Then from 2009 to 2012, he served as a trial attorney for the U.S. Equal Employment Opportunity Commission in Miami, Florida, where he litigated employment discrimination and retaliation cases on behalf of the federal government. In 2012, Brian returned to Atlanta, where he joined the law firm of Buckley & Klein, now called Buckley Beal, which is a premier plaintiff's employment discrimination and business litigation firm. And he became a partner there in 2016. Over these years, he's represented numerous individuals in constitutional civil rights cases brought under the Voting Rights Act, Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, Americans with Disabilities Act, and the Family and Medical Leave Act, as well as state tort law. He's tried multiple cases to jury verdict and taken appeals to the Georgia Supreme Court, the 11th Circuit Court of Appeals, and the United States Supreme Court. Forming the basis of our program today, Brian served as lead counsel and counsel of record for Mr. Gerald Bostock in proceedings before the Northern District of Georgia, the 11th Circuit Court of Appeals, and ultimately the United States Supreme Court. That case raised the legal question of whether Title VII of the 1964 Civil Rights Act prohibited employment discrimination on the basis of sexual orientation. Recently, unfortunately for us, Brian returned to our region, and he is now an Assistant Attorney General in the Civil Rights Division of the Washington State Office of the Attorney General, where he works on affirmative civil rights and enforcement litigation in several substantive areas. And I should note that he's currently leading a case against the Trump administration's attempt to limit anti-discrimination protections under the Affordable Care Act. So here to speak with us in a conversation moderated by Associate Dean and Professor Charlotte Garden in a program entitled Litigating for Justice, A Story of Softball and the Supremes, is our own influential voice and powerful advocate for justice, Brian J. Sutherland. Welcome home, Brian, and we're going to start with Professor Garden. Thank you.
Great, thank you. So I'm so excited to talk with you, Brian, about this case. I've got a bunch of questions for you. Once we have exhausted my questions, I'll open the floor to everybody else. And you can either use the hand raise function and ask your question, or if you'd prefer, you can send it in the chat to me or to Professor Coleman, and then we'll ask your questions aloud. So let me just jump in. So I think it'd be great to start out with just a kind of make sure we're all on the same page about what this case was. Some of our students will already be familiar with this sort of already landmark case, but could you tell us a little bit about what happened to Gerald Bostock, what his case was about, and what the legal question before the Supreme Court was?
Sure, and let me just first say thank you very much for inviting me, and thank you, Dean, and all the faculty for the invitation. I just wish I could be at Sullivan Hall in person, but that'll be soon. But it's really great to be back in Washington State, and I'm thrilled to talk about the facts of this case, or my former client, because he was such an incredible guy, is such an incredible guy. You know, in so many ways, he's he was the perfect person for this case because he's sort of an ordinary person who did some very extraordinary things in his life. He was born and raised in a small rural area in southern Georgia, which is called Valdosta. And as he explained in some interviews with the press during the case, in Valdosta, it's all about the 3 F's: faith, family, and football. And he was just kind of a regular guy from a regular family. And he grew up wanting to be, he was passionate about kids who were in crisis. He wanted to help children. And so when he went to school, he got his education in social work. And he ended up working with what in Georgia is called the Department of Children and Family Services, or DFACS. And he was a caseworker. So he had kids who were in foster care or otherwise involved in juvenile dependency proceedings. And he made sure that their needs were met and addressed that from the state side. He ended up moving away for a little while, and he was living in Florida, and he got involved with CASA, the Court Appointed Special Advocates Program, which I do want to note was founded by one of our very own King County Superior Court judges, Judge Sokup, in 1977 or thereabouts. But now it's a huge program nationwide. And so the program is essentially volunteer advocates come in and volunteer to be an advocate for a particular child who's in the juvenile justice system or juvenile dependency system. And they are the eyes and the ears for the court in terms of what's going on with that child and what's in their best interest. So Gerald loved this job, and when he moved back to Georgia in Clayton County, which is just south of Atlanta, he started being the coordinator for the county's CASA program. And he was really, really good at it. He was able to develop programs and events and a membership and a volunteer rate that was extremely high. In fact, he was able to achieve a rate of volunteering that was 100% coverage. So every kid in the juvenile system in Clayton County had their own advocate, which was a first in Georgia at that time. So he was really, really awesome at it. It's really his calling. And so everything was going very well until he joined a gay recreational softball league in Atlanta called the Hotlanta Softball League. And once this got out and it was known, and Gerald is a gay man, he was accused of mismanagement of the program funds, and which he alleged were false accusations and were pretext for discrimination against him based on his sexual orientation. But he was fired. And so he filed a charge of discrimination with the Equal Employment Opportunity Commission. And once the EEOC issued the notice of right to sue, he filed a complaint on his own in federal court. And then after that, he retained our law firm, and that's when I began representing him. But that's sort of the background fact of his case and what he's been pursuing.
So everything you just described makes Mr. Bostock sound like a completely remarkable person. And at the same time, the questions before the Supreme Court were sort of legal questions, so you hadn't gotten a chance to develop facts through summary judgment. But I imagine you spent a lot of time thinking about what is going to persuade a Supreme Court, especially of sort of 5-4 conservative-leaning Supreme Court. So could you talk a little bit about how you approached the question of, or how you approached the task of sort of framing the case for the lower courts and then for the Supremes?
Sure. Well, you may have noticed when I was just describing the factual background, I said quite a bit about Mr. Bostock before, noting that he's a gay man. And I think that that's really important because the entire point of his case and, all the cases that it impacts now is that a person's merit as an employee should be determined completely independently of their sexual orientation. That is, their sex or their sexual orientation has no relevance to whether or not they're a good employee. And I think that's important. That was an important way to present this case. And I think it's reflected in the briefing. And, it's sort of something that, should and does matter so much less than the wonderful service that Mr. Bostock provided to kids in need. And I think that's also an important aspect of the case in terms of what the Supreme Court needed to know and what the country needed to know, which is that you know, when a person loses a job because of discrimination, that's obviously bad for them, and they lose wages and suffer emotional distress, perhaps, and it really upends their life. But that's not the only loss that happens when somebody loses their job because of discrimination. It's also lost is all of their talents and abilities and passion that they bring to their work and the way that others are benefited by that. So in Mr. Bostock's case, quite clearly, you have kids in the juvenile dependency court system in Clayton County, kids who are in crisis, who need help, who need somebody to be looking out for them. And these kids don't have an advocate, perhaps, because the greatest facilitator and coordinator of advocacy volunteering that ever was is no longer doing that job. So who's losing out? Not just the person who gets fired, but also the people who benefit from their service. And that's true with respect to every LGBT employee throughout our country. And that was what was at stake in this case.
So you talked a little bit about wanting the public to understand about this case too. Would you talk a little bit about, I imagine you had to talk to the press or talk to the public as all this was going on. Could you describe how that all went? Yeah,
that was a pretty, I guess, exciting part of working on this case. There, obviously a lot of public interest, and so we did interviews with New York Times and Washington Post and many of the major television outlets, and it was it was pretty exciting. It was definitely 15 minutes of fame, I suppose. This case was interesting as compared with the companion cases because Mr. Bostock never got the opportunity, as you noted, to develop his case, the facts of his case in the trial court. So his case was dismissed on a motion to dismiss for failure to state a claim under Rule 12b-6. There were no depositions, there were no interrogatories or other discovery, and so in general, when you're dealing with the media, the public obviously has a justifiable right to know about matters that are of great public importance, but there's also advocates need to take a lot of care to be careful about what they're saying given pending litigation. And of course, we have ethical rules that relate to that as well. And so, it's something that is, probably criminal practitioners, prosecutors, public defenders think a lot about this. Other advocates and litigators, maybe not as much, but you certainly start to think about it a lot when you have a case before the United States Supreme Court.
So let's back up a little bit and talk a little bit about the legal issues. I mean, we've sort of been throwing terms around like Title VII of the Civil Rights Act. And I just want to make sure that, everybody in the audience is familiar with kind of the legal question. Can you talk a little bit about just what the legal question here was? And then maybe also how the case unfolded in the 11th Circuit? Because I know there were some kind of interesting developments there. Right.
So the claim that Mr. Bostock asserted is a claim for discrimination based on sex in violation of Title VII of the Civil Rights Act. And Title VII is a sort of major employment discrimination statute at the federal level, which prohibits discrimination in the workplace based on various protected characteristics, race, sex, religion. And so the argument presented was that Mr. Bostock was discriminated against because of his sex, based on the fact that he would not have been treated as he was if he were a woman. And this is sounds straightforward, except that there's a kind of a complicated legal backdrop here in terms of whether or not the sex discrimination provision of Title VII incorporates sexual orientation and gender identity. And so, sort of early on in 1970s, thereabouts, there were lower court decisions which indicated that no, being terminated because of your sexual orientation or discriminated against because of your sexual orientation is not sex discrimination. It's not protected by Title VII. But then there was a major decision from the Supreme Court in the late 80s called Price Waterhouse versus Hopkins, in which the Supreme Court held that sex stereotyping is sex discrimination that violates Title VII. So treating, in that case, it was Ms. Hopkins, who was a female accounting professional who was seeking partnership in the firm. And she was denied partnership because the partner said she was too macho and not feminine enough, and needed to, quote unquote, take a course in charm school. And so the Supreme Court upheld a judgment for her based on the theory that penalizing an employee for failing to conform to a stereotype that you have for them based on their sex is sex discrimination. And so between that and some other decisions, it became clear that certainly discriminating against a person based on the failure to conform to a stereotype of what a masculine man or what a man should be like, or you know, how feminine a woman should be, could overlap and provide protection for folks, protect them from being discriminated against because of their sexual orientation. There was also a Supreme Court decision in the late 90s called On-Call versus Sundowner Offshore Oil Services, in which a unanimous Supreme Court, in a decision authored by Justice Scalia, held that Title VII prohibits same-sex sexual harassment, even though Congress very likely was not thinking about that when it passed the statute. So with this, courts began to apply the Price-Waterhouse theory to claims of discrimination against gay and lesbian employees and some transgender folks. And then in 2012, I believe it was, the EEOC issued a decision in the federal sector, sort of looking back on Price-Waterhouse and On-Call and some of these developments and thinking more clearly about this sort of straight up textual application of Title VII, and concluding that the ban on sex discrimination also includes sexual orientation discrimination, because, quite simply, you can't think about a person's sexual orientation without thinking about her or his sex, because sexual orientation is defined by one person's sex in relation to the person they would like to be dating, right? So the EEOC issued that decision. Some lower courts started looking at it afresh as well. And then in 2017, the Seventh Circuit reversed itself and held that Title VII does prohibit sexual orientation discrimination. And the Second Circuit in the Zarda case held the same 2 years, maybe just the next year. And so we were down in the 11th Circuit, and we had a case not handled by our firm, but raising the same issue that was pending. And this was about the time when Mr. Bostock's case was filed. And so this was the Evans versus Georgia Regional Hospital case. We had a panel decision that said, no, we're going to stick with this 1979 Fifth Circuit decision before the circuit split, which said in a very summary sentence that sexual orientation discrimination was not included. And so, you know, obviously, if the Evans decision had gone the other way, that would have helped Mr. Bostock just go forward with his case in the trial court, but it didn't happen that way. And they petitioned for a rehearing en banc, and our court, at that point the defendant had filed a motion to dismiss, and it was pending, and the court stayed the ultimate decision on that until the decision on the petition for rehearing en banc. It was denied. The district court denied or granted the motion to dismiss. And so we immediately appealed to the 11th Circuit, and we knew that we have this prior panel precedent rule, right? So essentially we have this decision which says sexual orientation is not covered. A panel of the 11th Circuit is going to follow that decision unless the en banc court reverses it or it's reversed by the Supreme Court. So we petitioned for en banc hearing in the first instance. That was denied, and our appeal was rejected. And so we immediately petitioned for cert with the Supreme Court. And the sort of interesting thing that happened was that after this, you know, typically you might lose a case in the Court of Appeals and then petition for rehearing en banc to try to get the entire Court of Appeals to look at the panel decision. And we didn't have cause to do that because we had already done it. And it was, we filed our petition with the Supreme Court. But evidently, one of the judges in the 11th Circuit, sua sponte, told their colleagues about whether to rehear the case. That was voted down. And then it was Judge Robin Rosenbaum of the 11th Circuit who issued a published opinion respecting the denial of rehearing en banc. And it was an interesting and I thought very good opinion. And since we were at the Supreme Court, we filed a supplemental brief at the cert stage advising the court of that.
Yeah, and I think we should, just for students who are listening, emphasize how pretty unusual it is for a judge to write a descentile, as they're sometimes known, right? A statement respecting the denial of a petition to go en banc. So she must have felt very strongly that the court should be taking this case en banc and not relying on this, one sentence in a opinion that was by then several decades old.
Right, and so Judge Rosenbaum was also the dissenting judge in the Evans case. So Judge Rosenbaum had some opinions about the merits and evidently wanted to address them with the whole court, and also some opinions about the court's refusal to do that when the Second and the Seventh Circuit, or actually just the Second Circuit. I believe the Seventh Circuit was just a panel decision, but the Second Circuit had considered it en banc in Zarda. And so Judge Rosenbaum had some strong opinions reflected in that descentile about them not taking it up.
So let me ask about, so once it goes up, first of all, were you surprised when the Supremes took it?
No, I was not. I think this was an issue that had been needing an answer for a while. So I kind of saw this issue and knew it was one that needed to be resolved with some finality. I had been happy, of course, to see the Second Circuit's decision and the thorough analysis there, and the Seventh Circuit's analysis. It would have been nice to see the 11th Circuit en banc really engage with all of that, but I knew that it needed to be decided.
And by this time, if I'm remembering rightly, Mr. Bostock was fired in 2013. So years and years had gone by. This case had been pending and he had been waiting for justice. And then it arrived in the form of an opinion authored by Justice Gorsuch. Was that a surprise?
I will say, I was at the National Press Club and they asked me what did I expect the result to be, and I said, well, I think probably a 9-0 result, just like the on-call case in which the court said you apply the language of the statute to the situation, and that's it, which is a little tongue-in-cheek, of course. I was not really surprised about the result because I think there were the arguments in favor of interpreting Title VII in this way were and are compelling, and I think I was not surprised by the result, but I was maybe surprised by exactly what the message of the decision ended up being and who the messenger was. Like I said, I think the arguments were compelling, and there were actually a number of different arguments that were made in the briefs and discussed in the decisions in the Second Circuit and the Seventh Circuit, which weren't addressed by the Supreme Court. So if anybody's interested in those, I think, go and read the Zarda decision in our briefs, and a lot of interesting stuff there in terms of some of the other theories. But, as it is, Bostock, the opinion stands as this sort of monolith for a faithful application of the text to protect even those politically unpopular groups, which may not have been the intended beneficiaries of the statute. So it's sort of it's pretty epic, and I didn't necessarily expect that, but I'm certainly grateful for it, for my former client and for everyone else who will benefit from it.
Yeah, of course, Justice Gorsuch is famously a committed textualist, right? And so the two sides made arguments that they both framed around the idea of textualism, with the employer's briefs focusing on the idea of original public meaning, what would the public have thought discrimination because of sex meant in the 1960s? And Justice Gorsuch sounded like he was saying, no, that's not the way you go about doing textualism in a case like this. Do you want to say a little bit more about sort of what the opinion stands for and Justice Gorsuch's approach?
Yeah, it's definitely pretty interesting because you see between the justices, between Justice Gorsuch's majority opinion and Justice Alito's dissenting opinion, this sort of argument about who's a real textualist. Justice Alito says that the majority's opinion is textualism is like a pirate ship sailing under a false flag of textualism, which is that's going to be an interesting discussion in years to come. But the question really is, how faithful are you to the text of the law when it leads you to results you wouldn't necessarily expect? Do you follow it to results that are even maybe results that you wouldn't want to expect, that you don't want to see happen, but which are the natural conclusion of interpreting the plain language of the statute? And some folks talked about this being a hack test for the Supreme Court, which it evidently passed by ruling 6-3 in favor of that approach. It's a very methodical opinion. It goes through different pieces of the statute and really analyzes the plain meaning, applies them, and then explains how the case law supports that interpretation and application. And so it's very, and it also addresses many of the arguments, contradicting arguments about, well, if we apply the statute this way, what does this mean for this kind of a situation? What was argued as the parade of horribles, and after the hearing, there was a lot of discussion about why are there so many questions about bathrooms, and all of these situations that sort of weren't at issue in the case, but which may be issues in future cases depending on the statute invoked. But it's just Justice Kagan famously said, "We're all textualists now," and couldn't be more true, could it?
So let me ask you about what's next. What do you think are the cases that are sort of likely to kind of be teed up now, either for LBGT rights or for employment discrimination?
So I'll take the last part first, and it's interesting because I sort of think of it as as a person who focused a lot on plaintiffs' employment discrimination. I was seeing things in the decision that might relate to employment discrimination cases that weren't just the major holding. And there's a very interesting discussion in the case about the causation standard for discrimination under Title VII. Part of the analysis involved the question of, if a person's being discriminated against because of sexual orientation, how much and to what extent is their sex really the thing that's motivating the decision? Why is it not just their sexual orientation? And why can that not be understood separately and differently from biological sex? And Justice Gorsuch's opinion sort of explains how, I think correctly, that sexual orientation is defined in part by sex, and so it's a sort of ipso facto kind of thing. But beyond that, Title VII doesn't require that you prove that only your protected class status is the reason for your adverse employment action that you're complaining of. In other words, it must be a but-for cause of the adverse employment action, but it may not be the only cause. And this is something that is argued a lot about in employment discrimination cases, because part of the analysis is, the employee asserts that they've been discriminated against because of their race or their gender or whatever it may be, and the employer says, no, it's really because they were late or they violated this company policy or something else. And in plaintiffs' employment lawyers have been arguing for a long time that there may be some truth to what the employer says that's negative about the employee, but at the end of the day, if they would not have been treated the way they were but for their sex, then they win. And I think that there is support in the Bostock opinion for that that argument. It sort of makes clear, again, but for causation is not sole cause causation. So that's kind of a what I think is going to be a significant employment law effect. But you know, if you read Justice Alito's dissent, he outlines a huge number of statutes that prohibit discrimination on the basis of sex. And so there are any number of substantive areas in which discrimination against folks based on sexual orientation and gender identity are going to come up. You know, the 11th Circuit, and I think it might be another circuit, but I can't remember, but at least the 11th Circuit has held that Bostock means that Title IX, which prohibits discrimination in educational institutions, also prohibits discrimination on the basis of sexual orientation and gender identity. And so those are the issues that are going to be coming up. And I think that the big question in a lot of cases will be, why shouldn't Bostock control? It's a straightforward application of the text. And why doesn't that decision mean that the plaintiff, the LGBT plaintiff in this case, you know, shouldn't win?
So let's switch gears a little bit. You're an alumni, and whenever I talk to alumni, I like to kind of ask them about their law school experience and their career path since then. What inspired you to go to law school? Did you know you always wanted to work in civil rights?
I didn't. I knew I wanted to work in civil rights as soon as I got to Seattle University School of Law, but I did not always know I wanted to go to law school. I got my English degree from the University of Washington, and when I was studying there was an opportunity to get that degree, maybe focusing on less of this, I guess, like historical standards of English literature and more on, you know, literature addressing issues of race and gender and, you know, heterosexual norms and colonialism. I had a post-colonial literature course, which was fascinating, and really, really enjoyed it and became inspired to want to address issues of social justice. And for a while was thinking about doing, you know, teaching and doing that and trying to mold young minds. And but then around about this time, I was working as a file clerk at the Snohomish County District Court. And at that time, Judge Dwyer, who's now in our Court of Appeals, he was the judge there at that time. I'm really old, this as well. And I would watch new prosecutors and new public defenders try misdemeanor criminal cases in front of Judge Dwyer and other judges. And I thought, I could do this. And I thought, I want to do civil rights. I want to, you know, all these things I'm inspired by. I want to be a public interest impact litigator and do civil rights litigation work. And so when I got into SU, I was sort of focused on trying to connect with people who were into that stuff too. And I had an amazing mentor relationship with the late and great Joaquin Avila, who I miss very much. He was a really wonderful guy and really led me into doing everything I ever wanted to do. And so, yeah, I've been very, very lucky.
So if you were going to give some advice either to yourself as a 1L or to yourself as just a new graduate starting your legal career, what would it be?
I think I would, on one hand, I would reassure myself, if I could talk to myself, I would reassure myself that all of the late nights and, you know, sort of scurrying over to Lemieux Library when Sullivan Hall was closed because I still hadn't finished my homework, I would reassure myself that that was all worth it and I should keep doing it. Even though it was grueling, but I learned so much. And then I would also tell myself, or any student now, be patient and have patience about getting into your first job. You know, it took me several months to find a permanent full-time position. And I was really, really frustrated. And I thought, well, I worked so hard in law school. I went to law school. I worked hard. I should have a job. And it was frustrating. But I realize now that, you know, practicing law is there's a lot of personal and professional development that goes into it, and it takes time. And the right fit is the right fit, and that's more important than just getting a job or the job you think you want or need when you first come out. And and also I would say this, that and I think folks told me this when I was in school, so they're probably still telling people, but it's not, the profession is not the way it used to be, in that the first or second job you get is the job you're going to have forever. And I think that's okay, because I've been really fortunate to have a handful of positions, and I've gotten so much from each one of them. So I think that there is nothing wrong with that. And obviously you want to stick around in a job long enough to develop and contribute to that organization. But it's a really great thing to spend some time somewhere, and maybe you want to grow in a different direction, and then you go somewhere else, and then you're just all the while collecting skills and experience that you can bring to the benefit of future clients or agencies or organizations that you're with.
So that actually relates nicely to a question that somebody asked in the chat, and I'd wanted you to ask about too. So you've worked at the ACLU, for the EEOC, for a law firm, and now for the state. Could you reflect on those different settings, what you've learned from them? What are kind of the benefits and drawbacks of working in those different types of practices?
Yeah, and I think that's the right way to say it. There's benefits and drawbacks to each. I think so. When I did nonprofit work, it was with an impact litigation organization, the ACLU, and I think one of the upsides is you get to work on some of the most exciting, important stuff that you could imagine. But one of the downsides for me, anyway, when I was there, was that it's not typically a high volume of work, or at least not as high a volume of work as compared with private practice or some government positions. And when I was coming out of school, I wanted to learn as much as I could, as quickly as I could, in terms of doing depositions and filing complaints and discovery and trials and appeals. And in a lot of public interest impact litigation settings, you're focusing a lot of effort and attention on fewer number of cases. And like I said, that can be really, really exciting because of the subject matter. But at least for me, one thing I didn't like about it at that early stage of my career was not getting to do as much in court stuff. And so that could be a drawback. Government practice is wonderful. It is, you get to take advantage of resources that you might not have in nonprofit work, because you have all these different attorneys who are at various levels of their careers, who have experience that you can draw on. But government practice can also be more structured. And, for example, you might work with a government agency where you do trial work, but there's somebody else in a different department that handles the appeals. And so if you want to do the trial and the appeal, well, you're not going to get to do that in that position. Private practice is private practice, and it can be exhilarating, and it can be really exciting. And I learned so much so quickly in private practice. But obviously it can be long hours. Sometimes it can be a challenge to do all the things you want to do when you've got as much of it to do as you do. In private practice, you have the feeling of, there's a special feeling when you represent a client, right? And this is what I've found in representing individuals in discrimination cases, is that often these are folks who are disadvantaged by discrimination in our society, or for other reasons too. And they are not the folks who have the power. As their representative, you have the bar card that you can force the system to listen to them. And it's really something special that you can't, it's a great experience, and you get to be somebody's hero. And it's kind of the thing that I wanted to do when I came into school. I think a lot of people in law school want to do something like this, but I guess I would say to anybody who's thinking about thinking about it, it's there for you. It's a true feeling that you can have if you want to represent individuals who have been the victim of injustice, and that's great. You know, and if I had to say, is there anything I miss about private practice when I talk about my current position, which I'm very thrilled about, though, it's that because with the Attorney General's office and in government settings, you don't represent individuals. You don't have that individual relationship that you do with a client. Your client is the state or your county or your agency, and but by the same token, you have this opportunity to make, in an individual case, you have an opportunity to change somebody's life, maybe, if you're able to prevail, and to have an extremely meaningful impact for that individual and maybe the organization that they were a part of, if there's a systemic problem there. With government positions where you're working on larger issues that affect more people, you have an opportunity to make an even more meaningful impact for an even greater number of people. And so that's an amazing thing. It's just amazing. It's sort of, you get to work on, you think to yourself sometimes, they let me do this, they let me work on this. And it's a really great thing. And I'm really feeling that right now with the Attorney General's office, because we have an incredible team over there. Everybody that I'm working with is brilliant. And the Attorney General is very committed to civil rights. And so it's really awesome. And I couldn't think of a better way to come home than to join this office. And yeah.
That's great. So there are some great questions in the chat that I want to make sure we get to. And if people have questions they want to ask, feel free to go ahead and raise your hand. So the Dean asks, justice delayed is often justice denied. Can you update us on what happened to Mr. Bostock?
I guess I have to answer the Dean's question, don't I? So, I want an update myself, because we went to the Supreme Court, we presented the case, we obviously were successful. And so right now, to my knowledge, my former partners are handling Mr. Bostock's case in the trial court. And, that was one of the big things about this case, I think, was that Mr. Bostock was denied the opportunity even just to have his day in court. It may be he wins, it may be he loses, but he and other LGBT folks around the country ought to have the chance at least to prove their case and to try their case. And so he's now getting that opportunity. And so we'll see what happens with the case.
Yeah, finally, right? 7 years in. So a student asked a great question. Considering the dicta at the end of the Bostock opinion that allowed for religious institutions possibly to discriminate against people in the LGBT community, and now with a more conservative leaning court, how would you predict sort of things will play out in terms of the possibility that people will be able to, or employers will be able to use religious beliefs as a defense for discrimination claims against LGBT employees?
So it's a great question. And one thing I would say is, sort of for background, is to look at the Sixth Circuit's decision in the Harris Funeral Homes case, which was one of the cases, one of the companion cases to Bostock. It was the gender identity case. And so in the lower courts, the Harris Funeral Homes raised the issue of RFRA, the Religious Freedom Restoration Act. And so there's a lot of discussion and analysis there in the Sixth Circuit's opinion about that. It was not presented to the Supreme Court. So there was not a lot of analysis there about how that statute might interact with this situation in the instance of private employment relationships. I think clearly RFRA is out there, and it's reasonable to assume that it will be, that a conservative court would give it application to protect individuals who are, asserting their religious beliefs as a reason for why they're doing what they're doing. But there are requirements for when that statute would save the application of a statute that otherwise prohibits discrimination and is otherwise constitutional. And so I think those will be some very interesting issues going forward to be decided by the lower courts and also the Supreme Court. Is how far exactly does RFRA go, and what can it do, and what can it prevent?
Mm-hmm. Because the lower court in Harris had decided that RFRA, the Religious Freedom Restoration Act, could be raised as a defense when the EEOC pursued a case on behalf of an employee.
Right. And so if you had a case where an individual employee, EEOC was a party in the case, right? Which was one of the interesting things that that happened at the Supreme Court, was because the EEOC would have liked to, I'm sure, make the same arguments it made below in the Supreme Court, but of course the Solicitor General the Solicitor General's office are the lawyers who represent the federal government, and so you had two parts of the federal government on opposite sides of the issue with that. But yeah, to what extent would RFRA apply to a private employment relationship where the EEOC is not a party, or the government is not a party?
So there's a lot going on right now, and so feel free to not answer this question. But if you've gotten to read up on the Fulton case, which was just argued yesterday, do you have a take on that, or do you want to talk about that at all?
So I read some analysis on SCOTUS blog about it, and it's pretty interesting. It's pretty interesting too to think about how this current court is going to decide the question when a court from just several months ago, or 2 years ago, 3 years ago, would have decided it differently. Is it going to be a decision like Masterpiece Cake Shop, where there's sort of different threads that lead to a certain result, but without answering larger ultimate questions? Or is it going to be something more definitive? Hard to say, and especially hard to imagine or to think about, right? Is we have a new Supreme Court justice who's been there for about 10 minutes, and so how will the new justice sort of fit into some of the doctrinal leanings of the court? Folks have their own assumptions, to be sure, but how will the new justice fit into the process that the Supreme Court undertakes to reach its decisions? I couldn't say.
So let me just pause here to ask whether there are other questions from the audience. And let's see, another question that just came in the chat. What's your favorite law school memory? And then conversely, what was the biggest sort of challenge?
My favorite law school memory. I think I have so many wonderful memories. let me give you two. I'll give you one generic memory that really applies to, let's say half or 3/4 of every month for the entire 3 years, which is sitting outside on the bench on the internal side of Sullivan Hall, and just debating to no end all kinds of issues with the Federalist Society members, and trying to figure out, what does the rule against perpetuities mean? And I just had so many great experiences chatting and hashing stuff out with people. I missed that. That was really fun. It kept me in the library late because I didn't get my work done during the day, but it was great. And then one of my other really fond memories was a time when I participated in a sit-in demonstration. And at that time, there was a controversy brewing about the Solomon Amendment, which was statute, amendment to, I don't know what statute, I can't remember, but said that the school could not have federal funding for the library if it did not allow the Judge Advocate General to interview on campus. And CIOU had a non-discrimination policy, and we supported that. And I supported that with my friend Sarah Lair. And we sat in and we talked and we hung out with our Outlaws friends. And I love that. That was why I came to SU.
So it sounds like the community is really something you remember fondly.
Oh yeah.
Well, at the risk of putting you on the spot where there might be professors that you had in the audience, what was your favorite class?
I really liked property.
Okay.
I really liked property, and I've told people if I was going to be any other kind of lawyer, I would like to be. I just enjoyed. I enjoyed the rules. I liked trying to figure out the rule against perpetuities. I felt it was great satisfaction when I believed, rightly or wrongly, that I did understand it, and just liked it. I liked thinking about remainders and trying to figure that stuff. But there was a certain logic to it, and Professor William Altman was incredible, a great guy, and really prepared me a lot for everything because he would say, you got to read pages 92 to 99 tonight, and then there's notes, and I want you to take notes, and I want you to take notes on the notes, and then I want you to take notes on the notes on the notes, and so I did, and I always have.
Could you talk some about the how the Civil Rights Division of the AG's office makes decisions about what cases to pursue or what positions to take in cases?
I can say just a little bit about that. Those are above my pay grade, but we have a division chief of our division, and we have two managing assistant attorney generals, and then we have a whole team of assistant AGs as well as professional support staff, and we have the authority to investigate and enforce a number of statutes, including the Healthy Starts Act here in Washington, and the Fair Chance Act, which sets limitations on inquiries into the criminal histories of folks who are seeking employment. And the Healthy Starts Act, for those that don't know, has to do with accommodation for pregnant employees. And of course, we have our Washington law against discrimination, which we enforce, which I think is just so wonderful. I have to say, I practiced law in the South for a while, and I practiced law in Georgia for a large part of that time. And Georgia does not have a Fair Employment Practices Act at the state level, which is anything comparable to the Washington law against discrimination. And so it is a really great thing to have a policy community in Washington state where there's a strong policy against discrimination in the workplace and other settings, and a strong state law that backs that up.
So let me ask you, if you were, if a new grad who wants to go into civil rights work and wants to do it in a private practice setting, how do you, pay your rent and make your loans, and how do you manage?
Yeah.
Or how does one manage?
Sure. I did not know when I first started practicing law. I just wanted to do civil rights work. And I didn't know exactly what sort of options and opportunities there would be. But as I began to learn more about employment discrimination, I realized that, the employment discrimination field is sort of, it's wide open for all kinds of different advocates and cases to be brought. And, I think a lot of people think about, in order to be profitable with a firm, a small firm or their own firm, they maybe have to have, hourly clients they really can count on, or have some sort of niche for that. But, plaintiffs' employment discrimination cases, like other kinds of civil rights cases, they don't necessarily need to be they don't have to have a large amount in controversy. Right? You don't have to have a case where the person's salary was $200,000 a year and they have 3 years of lost wages plus, compensatory damages at some huge level, right? Because the statutes provide for reasonable attorney's fees to be awarded to a prevailing party. And that's critical for anybody who is thinking about representing a victim of discrimination, because it could be a case where the person was only out of work for a short time and they ended up taking another position. And so they really didn't lose all that much money. But it's the principle of the thing. They're a victim of unlawful discrimination. And if the case can be proved and the plaintiff can win at trial, then reasonable attorney's fees for the attorney incurred in bringing the case all the way through can be compensated. And so, and it was a very important policy decision made by Congress with a lot of the federal statutes, and it's attorney's fees are available under the Washington law as well. And it's a major deal because it makes it doable for small firms and for even individual solo lawyers to take those cases on.
So, of course, you returned to Washington and then the pandemic hit. Do you have advice for lawyering during a global pandemic or being a law student during a global pandemic?
I think that I will tell you the truth. When we first started in the pandemic, I kind of was thinking, I've done trials, I've done lots of depositions, and I like sitting across the table from somebody. I like being able to, sort of look eye to eye with somebody. And I thought, I hope I won't really need to know all of this, doing depositions remotely and all of these new things. I hope things are going to get better sooner than that. But, I'm realizing that there's a lot of cost savings. There's a lot of cost savings that can be had in doing remote litigation work, even if we didn't have to. So the one thing I would say to anybody who practices law right now, including myself, is, be open to these new developments in how we do litigation, because even if we don't have to do them, because things go back to whatever the new normal is, we may want to do them because it's cheaper than flying to Peoria to do a deposition of somebody or whatever the case may be.
Well, I hate to say this because I feel like we could chat forever, but I think we have to wrap it up. Let me just invite everybody to join me in thanking Brian. This was really inspiring, a really fun conversation. Thank you so much for being here.
Thank you.
The Zoom muted clap.
Thank you so much.
Thanks so much.